Welcome to the last live training of 2023, and we are absolutely looking forward now to 2024. 2024 is going to be a busy one in terms of the employment scene, lots of changes. And hopefully some of what you get today will give you an insight as to those changes which are to come. But as some of you will have seen on my email yesterday, I even had to add another slide into this presentation yesterday, because employment law looks like it's about to change, and it's not necessarily employment law, but it's all the stuff around it. So when we look at why HR changes, some of it is because there is primary legislation. There is new stuff that the government wants to bring in. They write new employment law. Some of it is due to case law. That's where a employment situation has ended up in an employment tribunal. The employment tribunal passed a finding, and there are learnings from that finding. We will talk about holidays and the changes coming to holidays shortly, and I'll explain how that employment law and that case law interact, because that's the best case sample where actually the case law completely undermined what the employment law was meant to be doing. Really interesting. There's also best practice. So the law always sets a minimum level, and what best practice does and what we do when we're advising clients and say, this is the base level, but actually what do you want it to look like in your business? And examples of that will be holiday, where you give enhanced holiday. It might be sick pay, where you give enhanced sick pay. Anything where you go above the statutory minimum becomes best practice, and that depends on what you can afford. It depends on the size business that you're in. So best practice comes in there as well. And then there's ACAS, and ACAS is the arbitration advisory service, the arbitration and conciliation advisory service. ACAS's role has evolved hugely over the last few years. And there are now various codes of practice, and we'll talk about some of them as we progress, where if you don't follow the code of practice, then actually if you lose in an employment tribunal, you could have a 25% uplift in an award against you. So you may say, oh, well, we're following the employment law to the letter of the law, but does it comply with the ACAS code of conduct as well? So you've got this huge melting pot of legislation and case law and best practice, custom and practice within your own businesses, your contracts of employment. All of that is what governs how you manage the people within your business, within your organization. Excuse me. And that makes HR more and more complex. What you then have is the changes in government. And obviously we haven't had a change in government for a long time now. Depending on your politics, you're either expecting a change or you're not expecting a change within the next 12 to 18 months. And that potentially is going to have a massive impact on the stuff that we're talking about today. Labour have said that if they get in, they will be making changes to employment legislation within the first 100 days of office. They may or may not be able to get that through. That is what they have said they're going to do. That doesn't mean it's going to happen, as we know. They can say whatever they want in opposition. It's what happens in practice, and then getting it through Parliament. So this smarter regulation to grow the economy, that phrase is underpinning several of the new things coming down the line. So there are changes that are being made so that we are, as a country, in theory, working smarter to grow our economy. The government put out a paper in May. They've now had lots of feedback to that. It's a consultation paper. They've issued a response to that. And as a result, there is a draft, it is still draft, employment rights amendment, revocation, and transitional provision. it's why it's written down, regulations being laid before Parliament at the moment. But they're working on a really tight timescale, and they're expecting some of this stuff to take effect from the 1st of January 2024. And I will, as we go through each of the changes that's coming, I'll tell you when we expect that to take effect, but it doesn't necessarily mean that's when it will take effect. It's complicated. I'm not a lawyer. There's a reason I'm not a lawyer. I like the very practical, what does it mean for my business? I don't normally put in a lot of the names of the policies, of the legislation, because actually I don't care what the legislation's called. I just want to know what it means for my business and for the businesses of my clients. And that's the same, I'm sure, for all of you, unless you happen to be an employment lawyer, in which case, if you're here, thank you very much. So what's coming down the line? Well, there were 21 pieces of legislation that we are expecting. And as you'll see, I now have a very messy little chart as I shoved immigration on there, following the announcements made on Tuesday of this week. So there are 22 pieces of legislation that we are now expecting. Some of those are hitting this 2024, this coming year. Some of them are going to go through Parliament this year, but won't actually impact until following year or even 2026. But we'll go into each of those in detail. As always, if you have any questions, I'm not monitoring the chat, but please put your questions in the Q&A box and I will try and answer them as we go along. Okay, let's dive straight in because we've got quite a lot to cover. I'm not covering all 21 topics, just the ones which I think are relevant to most of our clients and from the people who I could see had signed up for today. So, Working Time Directive. I remember when the Working Time Directive was introduced and all of the regulation that was put in around record keeping. Part of that, making smarter regulation for growth. This is one of those areas. So it's due to come into effect in January 24, so literally 3 weeks' time. But we don't know what that looks like until that bill has or hasn't been passed through Parliament. But what we're thinking it's going to look like, and what the premise of passing that is, that employers are not required to record working hours for every single employee, every single worker, every day. So when the regulations were brought in, it was very, very strict. What time are they starting work? What time are their breaks? How long are their breaks? What time are they finishing? How many hours have they done? And it became a real headache for a lot of businesses just to keep that record keeping in place. Now, a lot of businesses have got that. I'm not expecting people to scrap it altogether, but certainly it gives people an opportunity to look at what they've got in place and say, is it still fit for purpose? What it's not doing is removing the requirement to comply with the working time regulations. So people should still be working no more than an average of 48 hours a week. There may be some weeks where you go over, but there should then actually be the counterbalance and the weeks where you are under that. Rest breaks. People need certain amounts of rest breaks per day and certain amounts of rest breaks per working week. Okay, so it's really important, and between shifts as well. So if you're working more than 6 hours, you're entitled to a 20-minute break. Best practice, so that's the entitlement. Best practice is that most businesses give half an hour to an hour. Okay, so again, that's, you know, what is reasonable in your particular situation. 11 hours at least between shifts. And then at least 24 hours clear non-working time in any 1 week. Those you still have to comply with, okay? And the holiday entitlements you still have to comply with. The relaxation is on the record keeping, okay? So I hope that one makes sense. Next one. So this is one of those areas where the law, I thought, was pretty clear. Now, this legislation comes from the working time regulations. So all of the holiday laws, the move to, 4 weeks, 20 days, 4 working weeks, plus public and bank holidays, prorated for part-timers, etc. All of that comes from the working time regulations, which we've just been talking about. And it's quite hard to give that to people who are irregular hours, so people on 0 hours contracts, flexible hours contracts, that sort of thing, and also people who work part year. Now, there was a case that was going on for a long time, many years, that went all the way up to the Supreme Court. And the Supreme Court overturned this use of the 12.07% formula. And it was something which many employers had been using when they'd been calculating the amount of pay and the amount of leave and therefore the pay that those workers were entitled to. And the Supreme Court overturned it. And even at the time, I turned around and said, this is not workable. I ran the calculations on my daughter. If you want to look at this stuff, there's loads of blogs and contents on our website about it. But I used my daughter as an example because she'd been on my payroll for a number of years. She worked for me for 12 weeks during the summer, and 2 years ago now, I think, between A-level and uni. But this change in the legislation meant that she was still entitled to 5.6 weeks of full pay because she'd worked for me full time for 12 weeks. And according to the change that the Supreme Court made, that meant that she should still have 5.6 weeks. So not only was it the 12 weeks, but an additional 5.6 weeks. That was barking. It was mad. And the government looked at that case law and went, well, that's not what was intended with the legislation. And they're now putting in place something to fix that. So as long as it goes through, then, and there's a catch here, if your holiday year starts in April 24 or any point after that, then you can use the 12.07% formula for calculating leave and pay for your ad hoc, part year, seasonal staff, workers, etc. However, if, like many organisations, your annual leave year starts on the 1st of January and goes through to the 31st of December, you cannot legally bring this change in until January 25. Okay, the regulations are in Parliament at the moment. That may change, but at the moment, the ruling from the Harper Trust versus Brazil, if anybody has the urge to go and look at this legislation, be my guest. It's pages and pages. But just look at when your annual leave year starts and look at when you can actually go back, if you had it before, to that 12.07% formula, because you can't do it from January 1st, 2024 at the moment. Okay, I can see some questions, so I'm just going to look at those. Is there a difference between documentation and practice, i.e. if we state that this is your hours and breaks and they choose not to do them, what's our obligation as an employer? Great question, Sarah. We may not notice, especially with hybrid working and the senior level CEO, etc. Okay, so that's a great question. If you end up with any of this stuff, it's only a problem when it becomes a problem. It's only a problem if you end up in an employment tribunal or even before ACAS. So if you're having to defend your policies in any way, shape or form, it used to be that they would look at what's in writing. Nowadays, they'll look at what happens in practice. However, they will also look at how well you as management try and enforce it. So, for example, if you're talking about senior level, so the CEO or the director, they're in charge of their own time. Okay, so if they choose to work through their lunch break or they choose to work stupid hours, then it's kind of on them. However, if they have maybe trustees of a charity that are constantly contacting them out of hours, are constantly hounding them even when they're on holiday, then they could bring a claim, yes. So it kind of depends on where the authority really sits. If you've got a member of staff who is on holiday, you shouldn't be disturbing them. They're on holiday or they're on a rest day. And if you as the employer keep hounding them and therefore they're having to work, or you put a lot of pressure on them not to take their holidays, then that's actually where you are in breach and you can be held responsible. So it does very much depend on why people aren't doing what is on paper and why they're doing what's in practice. So I hope that answers your question, Sarah. Jackie, so pleased to hear that the 12, funny Jackie, I did think about you when I saw that it was coming down the line, but yes, 25th of January, January 25, I'm afraid. So we have kind of come up with a potential cunning plan, which is that you could change your holiday year on a one-off basis, or even for a couple of years, or even permanently, or even try it for a couple of years. You would need to do it carefully. You would need to consult with staff. You would need to make sure that the holiday that they're owed is paid out and all sorts of other complicated factors. But that's one workaround that we got to in a brainstorming session. But I am a little concerned that if you end up in an employment tribunal, they might look at the timing of that change and say, well, you were just trying to get around it. Can you do holiday year from April just for your new starters? Yes, potentially. But again, then you just need to think about whether you're going to align them eventually or whether you're going to move the whole company over eventually. It's quite difficult when you're working two holiday systems. So just be really, really careful trying to put fixes in. We've had the idea, but you just need to think it through very, very carefully. Jackie, call the team and they'll help you with that. Emma, our leave year starts in September, so that's great because you're after April 24. We have lots of term time workers, yep, and anybody working in education is likely to have a September start date. Also, quite a lot of the Jewish charities, Jewish organisations will start with the Jewish New Year, which is in September. So it's not everybody that's going to have that January start date. It makes sense for me for us to bring it in then. Yes, absolutely. However, we give 22 days rather than the statutory 20. How does that affect the 12.07%? That's really interesting. We can run the calculation for you, Emma. Again, you're a client. There is a calculation. I think it's off the top of my head, it's 13.8 or something like that. I can't remember offhand, so don't quote me on that. We can calculate it for you specifically. You shouldn't treat your part-time staff any differently to the way you're treating your full-time staff. But there is one thing that we have seen, and we don't know whether it's going to get passed or not yet, is that they could just say that as long as organisations are meeting the 5.6 weeks, then that's fine. I don't think that's going to get through. I think that the part-time workers legislation will mean that if you offer 22 days plus public and bank holidays to your full-time staff, then you need to do the same for everybody else, because otherwise you're going to be in breach of your part-time workers legislation. It's all connected. Right. Sarah has come back with another one. How does this impact on the salary of term time staff i.e. full-time holiday allowance now back to pro rata, so salary should be less? Don't quite understand that question, Sarah. Let's connect afterwards and I'll answer that specifically. Let me move on now. Because we've got rolled up holiday coming back as well. And this was something that was removed also a while ago. Again, April 24 onwards. So there was a time that if you paid somebody £10 an hour, you can't now because it's below the national minimum wage, but if you did pay someone £10 an hour, then you could also pay them for their holiday accrued in that particular month, as long as you put it as two separate lines on the payslip. So you might put 10 hours at £10 an hour, which would equal a base salary of £100. You can see why I'm using the £10 here. Plus 10 hours for holiday pay at 12.07%, which comes in at 120. No, it comes in, sorry, at £1.21 an hour. So instead of being £10 an hour, it actually works out as £11.21. You can't put £11.21 as their hourly rate. You have to show it as £10 an hour for base salary, and then the £1.21 for the holiday pay. And as long as you show the 10 hours for each of those, and that comes to your gross salary, then you used to be able to pay that as long as it's two lines on the payslip. That was abolished. Because people were taking the holiday pay instead of taking their holidays. And the whole point of the working time regulations is that people take their holidays. So that was abolished. It's being reintroduced. It's not being reintroduced for people who are part-time, but for people who are part-year, or people who are irregular hours, 0 hours contracts, and they're genuinely not working for you a lot of the time, then you can pay them for the holiday that they have accrued in the same month that they've accrued it, as long as it is really clearly separated on their payslip, and that the holiday pay is at the same rate, so either 12.07% or higher if you offer your full-timers more. And it's not included in their hourly pay. It must be split out separately. Okay. Yeah, I think I've just covered everything there. Yeah, I think I've covered in there. So again, these regulations are in Parliament at the moment, and it's all supposed to be about making life easier. This is exciting for a lot of employers, especially people who use people who are seasonal, or people who help 2 or 3 times a year. This is a great way of making sure that people are getting paid for what they're entitled to, rather than having to faff around calculating, but only for holiday years after April. National living wage. So regularly on our People Talk newsletters, this is the back page. Usually the first couple of editions in the year will have this on the back page. It's announced every year. It takes effect in April every year. Interesting change this year. So those of you who are can see this clearly, on the left-hand side, you can see a little figure in green. And on the right-hand side, that green figure has disappeared. And what they've done, and they've done this a couple of times over the past few years, is that they've reduced the different number of bands there. So you have your apprentice rate, you have your 16 and 17-year-old rate, your 18 to 23-year-old rate, I think it is now. At the moment, you've got a 23 to 25 and a 25 plus. The 25 plus rate is disappearing completely. and it's going down to anyone over the age of 23 will now be on that top rate, and that top rate is going to be £11.44. Okay, £11.44 per hour. And what this table does is it says if somebody is working 35 hours a week, this is what their annual salary would be. And that includes their holiday, because of course, remember, you're paying them for 5.6 weeks holiday minimum. So this is based on a full working year at 35, 37.5, and it goes up to 48 hours per week. So if you have salaried employees, this is a really good place to check to make sure that you're paying your salaried employees above that £11.44 per hour. I've got another question. 12.07 for annual leave equals 20 days plus public and bank holidays. What's the percentage rate for annual leave at 25 plus public and bank holiday? Okay, so that's the same question as Emma was asking for before. I don't have those figures off the top of my head. What I will do is literally now, while we're talking, I will write down and I will email you afterwards. What I might do is actually put a little table together. Now that this is coming back, I'm quite excited, but we do have a calculator that we've used for this before. And what I'll do is I'll send that out to everybody who's on this call today, because I think that just will make it a little bit easier to see. So Emma, you were 22 and Addy, you're 25. But what I'll do is I'll send out the table, which goes from 21 days up to probably 30, because we do have a couple of clients that are at that top end. So I'll put that together over the next few days. And also, if it makes a difference if the person is part-time as well as part-year, yes, you will always pro rata a part-time employee's annual leave. So if you have part-time, part-year, you're doing multiple calculations, because so if somebody works, if they're a 0.5 FTE, so if the contract is for 40 hours, they're contracted for 20 hours, instead of getting 28 days holiday in a year, they will only get 14 days holiday in a year. So if they're then part year, then that gets prorated as well. So you need to look at how many weeks in the year, what the FTE, full-time equivalent, is over across the whole year, and reduce it down again there as well. But I'll put a little chart together and send some of those calculations out to you. It will make another infographic. Thank you. Cool. Oh, perfect. Okay. The next one that's coming down the line, I'm going to need to speed up here a little. Leave for carers. So at the moment, if you have children that you need to care for, if you've got elderly parents, you're allowed to take emergency time off to arrange for the care of a dependent. And that's if normal care arrangements have fallen through or fallen apart, or if there's a problem. So if, for example, you have a child who is suddenly sent home from school sick, you're allowed some time off to arrange alternative childcare, but any other time would need to be taken as holiday. Your employers don't have to grant that holiday time. It could be taken as unpaid parental leave. You have a certain amount of time, but again, most employers' statutory requirement is that you have to book it in advance and it has to be approved. What this is saying is that you can take a week of unpaid leave. There is no requirement for employers to pay this, and it's for providing the care as well as arranging for care of a dependent. And it doesn't have to be a child. It could be an elderly parent. It could be a sick auntie. It could be, as long as it is for the care of that dependent. Okay. Now, businesses are going to, there will be best practice around how you check that the person is actually caring for a dependent and they're not off on a jolly. But it is unpaid. So whether or not there's uptake, we don't know yet. There are a number of entitlements that people have at the moment, but they don't take because it's unpaid. So we don't know how big an impact this is going to have on employers. But it's something that is coming in. We've been told it's coming in 2020, in April. And we're just waiting for the regulations that sit behind the legislation. So when they pass legislation, they then have to write the regulations to have the legislation take effect. I hate employment law. Tips for workers. So this is applying to anyone who is probably in restaurants, hospitality, that kind of thing. And there have been quite a lot of changes in this area over the years. There's this trunk system, bizarre word, TRONC, I believe. But it still hasn't been working quite as much as they'd originally hoped it would. But it's also now for workers as well as employees. So if somebody is a temporary worker, if somebody is a seasonal worker, they're not necessarily classified as an employee. They might not be on PAYE, they may not be on your payroll, okay? But the tips, they are still entitled to. So all tips and service charges have to go to the workers. You can't make any deductions. And there has to be a fair method in place for distributing it. Now, this is partly where the trunk system came in. It was partly so that people in the kitchen got tips as well as the service staff. There's all sorts of stuff around that. But they are working on a code of practice. And I think this one's being done by ACAS for fairness and transparency. So what they've said is that the employer is responsible for ensuring that the tips coming in are distributed in a fair way, but also so that it's completely transparent. So everybody can literally calculate how much they would be entitled to. And as it says there, that's going to include agency workers and temporary workers who aren't necessarily on your payroll. So there's going to need to be mechanisms in place to pay those people either through their agencies or their employers or directly if they're invoicing you. Just a side note here, I've discovered that a number of restaurants think that their full-time waiting staff can be self-employed and invoice the business. That's not the case. If somebody is working full-time, part-time, regular hours, they're working on a regular basis, then those people are employees. And to engage them as self-employed, you're in breach of employment legislation. You're also in breach of tax legislation. You're opening yourself up to an HMRC inspection. I don't think it applies to anybody on this call today. I'm sure you wouldn't be doing that, but we're dealing with more and more restaurants where we're discovering some very, very strange practices. So just let me be very clear about that one. TUPE, I've put there, it's horrible legislation. TUPE is the most horrible legislation there is when it comes to employment law, in my humble opinion. TUPE applies sometimes even when you don't think it applies. I know of at least 2 instances where solicitors have been buying and selling businesses on behalf of their clients, supporting their clients to do so, and have not taken into consideration the fact that TUPE applies. I had one solicitor phone me up. He said to me, TUPE doesn't apply in this situation, does it? And I said, well, why would you think that? He said, well, oh, TUPE applies, doesn't it? And I went, yes. The whole sale of the business fell through because they hadn't taken into consideration TUPE. Basically, when one business sells to another business or merges or becomes another entity in any way, shape or form, then the staff are protected. That includes, and this is where we come across it most, with security companies and with cleaning companies. So if a golf club like the one that I'm sat in today had a contract cleaning company, which they don't because they employ the lovely cleaner here, but if they had a contract cleaning company and they decided they were going to change that contract cleaning company and bring in another contract cleaning company, the staff who are here cleaning every day would transfer to the new employer. They would still be the cleaners for this golf club. And the same applies with security guards. And people think that by changing the provider, they're going to change the staff. That's not always possible. Okay, that's not always possible. Sometimes it is. Sometimes the organisation is big enough and the contracts allow for somebody to be moved to another site. That's fine. TUPE requires consultation with the staff. And if the staff are unionised, or if enough people are being made redundant, or sorry, not being made redundant, are being transferred, then even if they don't have representatives, up until now they've had to elect representatives. What this piece of legislation is saying, that if less than 10 employees are being transferred, even if the business is like, I don't know, 250, 300 people, but less than 10 employees are being transferred, you no longer need to go through the process of electing representatives, group consultation, and then individual consultation. Likewise, if the business has 50 employees, you don't need to go through group consultation. You can go straight to direct consultation with the staff being affected. I hope that none of you have to use TUPE. I know that Felix is on this call and is familiar with TUPE. I'm not sure who else. I haven't seen anybody else that's particularly springing to mind at the moment. But cleaning companies, security companies, as well as mergers, acquisitions, and sometimes disposals of companies as well. Okay, so that law is due to take effect. It's kind of, we know it's coming. And it's coming for a transfer on or after the 1st of July. So if you're thinking of making structural changes to your business, you might just want to think about the timing of that structural change. Not saying anything. Flexible working requests. Meet Frank. Those of you that haven't met Frank, he features quite a lot on my social media. And Frank is the elephant in the room, and he helps employers and employees to have difficult conversations, to have frank conversations about difficult topics, which are generally the elephant in the room. The rules are changing for flexible working requests. The legislation has already been passed, but we're waiting for it to take effect. They've said it will take effect approximately 12 months after the legislation was passed. The legislation was passed in July 23, so we're expecting it to take effect in July 24. However, the legislation has been passed, but we require statutory regulation on this. At the moment, the statutory right is to have one request per year. So if for any reason an employee put in a request and you turned it down, they would have to wait a year until they could put in their next statutory request. That's changing, and people are now going to be able to put in 2 requests per year. At the moment, most of our clients go back pretty quickly. You know, most of our clients go back within a month. Bizarrely, there is a 3-month period at the moment. That's being reduced to 2. That, I think, is absolutely, you know, the right thing to happen. And even with the 2 requests per year, I would expect there to be some kind of process of consultation. If somebody's put in a request, have the conversation, understand why they're requesting a change. A flexible working request is a permanent change to the employment contract. So if somebody just wants to work flexibly for a short period of time because there's a particular problem, that wouldn't necessarily be handled as a statutory request. It's not necessarily a permanent change. Okay. The big change which is coming and it's not in the legislation, but the government have signalled their intent, and I'm absolutely convinced that if Labour gets in, there is no question about this being passed, is that it will be a right to request flexible working from day one. So at the moment, someone has to have 6 months of service before they can put in a statutory request. You could, under the new legislation, new regulations, you could advertise a job for full-time Monday to Friday working in the office. You could interview someone who says, yes, absolutely, I'm up, I can do Monday to Friday in the office, 9 to 5, not a problem at all. They join you on day one and they say, my situation's changed, I can only work 3 days a week and I want to work those days from home. They will now, under these changes, be able to put in a statutory request to change their new contract of employment. Please do not shoot the messenger. This seems bizarre. I'm really, really hoping that this bit of legislation does not get put through. We do know that the government changed their minds. They've made a massive U-turn on some legislation recently because it made no sense. And I'm hoping that this also goes that same way. We'll see. We'll see what happens. And I'll talk about the other one when I talk about sexual harassment prevention shortly. But this is one where I think it's going to cause a real problem for business owners who go out and recruit on one basis. Day one, the employee turns around and says they can't do that. You do still have the right to say no. And we thought they were going to reduce the 8 reasons to 5, but they haven't. They've kept all 8 statutory reasons for declining. Can't remember what they all are offhand, but it includes things like it doesn't work for the business, but you really have to prove that it doesn't work for the business, that it costs too much, that it's not feasible. You know, if it was somebody who was working on the shop floor and they requested under flexible working to work from home, you would be able to reject that flexible working request because you are able to prove that it does not work for the business. However, if you have a head office function, for example, in a large retailer, then you might have to actually consider whether or not you could move that person to head office role if you have a role available. So there are still reasons why you can say no, but they have to be really good, strong, robust business reasons. Got another question here. Yes, Jackie, you're right. Most companies change cleaning provider as the staff aren't meeting the required standards. I would always say that if the staff aren't meeting the required standards, go back to your provider and tell them that you want a change of staff. They will need to take the staff through a disciplinary or capability process, and you should be given someone new. Changing your provider isn't going to fix the problem. If it comes down to cost, if it comes down to lack of customer service from the parent company, then that's why you would change your provider. But if there's a problem with the person performing the role, then they need to be performance managed out, and you're the customer. And if you don't want someone on site, you are within your rights to turn around and say, I no longer want this person on site. Will you please, remove them? Oh, Emma, are we obliged to tell staff if the flexible working legislation changes, or do we just leave it to them to find out? You will need to update your policies and procedures to make sure that you stay compliant. So if you have an employee handbook, you would need to update your handbook. You don't need to reissue people with a new contract of employment, but most of the time flexible working isn't in the contract of employment. So when you update your handbook to make sure that your handbook is compliant with the new legislation, and you ask your staff to sign to accept the new copy of the handbook with their new policies and procedures for the organisation, good practice says that you say, And here is a summary of the changes. We have introduced updates to the sexual harassment policy, the carers leave policy, the pay policy for 0 hours workers, the flexible working policy, etc. So I would at least list them, even if you don't blatantly go and jump around and tell them what the change is. But yes, you should make sure that your handbook's up to date, and you should get them to read and sign that they've made those changes. Okay. I'm very conscious we only have 10 minutes left, so I am going to try and just whiz through some of these quickly. Right to request more predictable terms and conditions of work, September 24, we are waiting for confirmation. Where you have people who are 0 hours, but they are always working the same hours, they are now going to have a right to go on to a permanent contract with predictable hours. And that can include working patterns as well. So if they're regularly working certain hours, certain patterns, then they have a right to request that put in writing, and that made their permanent terms and conditions of employment. So, and again, if Labour get in, they're threatening to take away 0 hour contracts completely. So again, that's going to be a little bit more of a challenge. We're going to need to watch this space, but that's a change that you need to be aware of. This is a big one. I thought this was coming in a lot sooner because it has had royal assent, but we are in a transitional phase. This is the one where there was a backbench rebellion by the Conservatives over the responsibility of an employer to prevent sexual harassment from third parties. So all employers have to prevent sexual harassment in their workplace. Okay, that is, at the moment, you have to take it really seriously, and you have to do an investigation, and you have to respond to grievances, etc. From October 24, you have to prevent it. I would suggest you start preventing it now. Sexual harassment has no place in our workplaces whatsoever. I've been training this stuff for the last 5 years. But what was going to come in was that if, and I'm going to use a pub because it's the most obvious example, but you may well be able to think of examples in your workplace too. If a customer comes into a pub and starts chatting up the bar, let's say a bar lady, or barmaid, whatever they're called, and starts sexually harassing her, I would say even harassing her, whether it's sexual or not, then the employer was going to be held responsible for the behaviour of that client coming into the bar, even though it couldn't be predicted. That bit of the legislation got removed on the second reading in the House of Lords just before this was made legal. Okay, I would say good practice. You are responsible. You are absolutely 100% responsible for the physical and psychological health and safety of your staff in your business. I would suggest you do everything that you can to prevent sexual harassment happening, whether it's from suppliers, donors, trustees, senior management. McDonald's and others are all over the press constantly at the moment because of sexual harassment. Do not end up in an employment tribunal. Do not end up across the front pages of the newspapers for having allowed sexual harassment in your workplace. You get more of what you tolerate. Zero tolerance, please. Please, please, please. Hire and refire. No, that didn't make sense at all. I'll say that again properly. Fire and rehire. P&O got caught out on this probably about a year or so ago, maybe a little bit more, where the employer literally did a video call to all staff and told them that they were fired, and that they were being offered new contracts of employment if they wanted to sign them. that caused absolute uproar. And as a result of that, statutory code of practice has been brought in. Okay, we don't know exactly when it's going to hit, but the code of practice, this is where ACAS have got this code. If you don't follow it and you end up in an employment tribunal, then there will be a 25% uplift in any award against you. If you need to change the terms and conditions of your staff, then you need to consult, and you need to consult fully, and you need to change them by mutual agreement. Dismiss and re-engage, so fire and rehire, should absolutely be the last resort. You would want to make people redundant if you're trying to achieve cost savings before you go to a fire and rehire. Okay, anything you can to avoid it. Very bizarrely, I got told last week that a consultation was taking place within P&O. Again, it's actually Cunard Shipping or something now, I think. And they put on the form, on the HR1 form, when they were talking about these changes, when they submitted the form to the government department, that they were reconsidering fire and rehire, having not learnt their lesson last time. Unbelievable. Right, this one, the Act has had royal assent and we're just waiting for regulations to bring it into force, but we're not 100% sure when it's coming in. The fact that we're just waiting for regulations that's already legally there means that we should be working as if this is in place already. There's already huge protection for people while they are on maternity leave. What this is saying is that there is going to be greater protection from the time that they tell their employer that they are pregnant up until 6 months after they return from maternity leave. Okay, now the biggest issue with this tends to be around redundancies. You know, if you're shutting down the business, then you are going to make somebody redundant, whether or not they're on maternity leave or not, whether or not they've just returned from maternity leave. If you're shutting down the business, you have no alternative. However, if you're just picking out a few people to make redundant, don't touch these guys. They are protected. Even if they're in roles that you need to make redundant, you're going to need to find them other roles within the business. Okay, anybody who is pregnant, anybody who has returned from maternity leave, and anybody who has returned from adoption leave or shared parental leave. Shared parental leave is where the parents, mother and father, two mothers, two fathers, whatever it is, where they split the year's maternity leave between them. So perhaps they might take 6 months each, or one might take 9 months and one might take 3 months. That's shared parental leave. Okay, but these protections are going to include those people as well as the employees who have had maternity leave, the baby, etc. The next one is that we know from April 25, eligible parents, and that is likely to be people who have worked in the business for a certain amount of time, will be entitled to neonatal care and pay. The pay will be at statutory rate, absolutely convinced about that. They won't introduce any other rate. So whatever your maternity pay rate is at the time, then that will apply to neonatal pay. And it's in addition to maternity leave. So if a parent has a child that ends up in neonatal care, their maternity leave won't kick in or is put on hold and then continues after the 12 weeks of neonatal care. Okay, if the child is in neonatal for longer than 12 weeks, then the maternity or shared parental leave kicks back in. Okay, we are waiting for the regulations, but that is coming down the line. We know that's happening, and we're thinking it's going to be April 25. Non-compete. I always say that a non-compete clause is not worth the paper it's written on unless you are willing to enforce it. Okay, but non-competes at the moment, generally 6 months, 12 months, going to be limited to 3 months. Don't shoot the messenger. You can still use paid notice periods. You can still use garden leave. Okay. You can still put non-solicitation clauses into your contracts. You've still got confidentiality clauses that are enforceable. And there's all sorts of rules if you're a public sector organisation about business appointments and all that sort of thing. Okay, we know these changes are coming. The official line is when parliamentary time allows. So we don't actually know when they're going to hit, but they are absolutely going to reduce non-compete clauses from 6 months or 12 months that people use now, and they're going to limit them to 3 months. Auto-enrolments. At the moment, employers only auto-enroll people who are earning over a certain amount of money and who are over the age of 22. That it's had royal assent. Again, we're waiting for the regulations. We don't know when that's going to take effect, but that £520 per month, I think that's the bit that's disappearing. I think that's the bit that's disappearing. And they're definitely reducing the age to 18. Although, as we know with the sexual harassment changes, things do change at the last minute, but that's the intention. Okay, so pension changes. If you've got younger workers in your business who are not currently eligible for pension, the chances are that they will be going forward. Okay, data protection. This is all about making business simpler, removing some of the regulation. It's currently progressing through Parliament. It's going to clarify what a legitimate interest is as a grounds for processing data. The third bullet point there is really interesting. We know, because in some cases we do it, that at the moment, if you think that a business is holding information on you that they haven't shared with you, then you can put in a data subject access request to get access to that information. And at the moment, if it's manifestly unfounded or excessive, the excessive stuff would be somebody who's working for an organisation for 25 years asking for everything that you hold on them. That's excessive. That is excessive. Try and talk properly. But sometimes people put in claims just to be difficult. And that's the bit that's going to be introduced, that's going to be stopped. People can't bring claims in to be difficult. However, if you think that you've been moved from one department to another department, so that you're in a department that's going to be scrapped in the future, and you believe that that process started 6 months or a year ago, and that whole reason for that move was so that you could be made redundant, that's not vexatious, that's not manifestly unfounded. People would still have an opportunity to bring that claim. Okay, so just keep an eye on that. The other thing is that data protection officers are going, and a senior within the business is going to be responsible for monitoring and ensuring compliance. I will find out more about that, but we don't know exactly what that looks like at the moment because it's still going through Parliament. Immigration, this is the slide that I shoved on yesterday evening because of the announcements that were made on Tuesday. So at the moment, you can sponsor people if you're offering a high enough salary. That salary is increasing from £26,200 to £38,700. That's a huge, huge, huge increase, 50% increase there or thereabouts. Going to scrap the 20% salary discount for shortage occupations, but they're introducing a list of immigration salaries, is the way that it's been proposed. This will all come out in the wash over the next few days. I have seen this morning that Robert Jenrick, the immigration minister, has resigned over this. don't know what that means going forward. Care homes, anyone who's working in the care sector is going to be massively affected because they're not going to be able to bring their dependents to the UK. That's going to make a massive difference to people coming into the UK. And also, you're only going to be able to get sponsorship for care workers who are doing regulated activities as defined by the Care Commission, Quality Care Commission. Okay, so they will have a list of what regulated activities are, and you can only get sponsorship visas for people doing those regulated activities. Okay, there's also going to be big restrictions put on the dependents of students and graduates. So graduates, when they graduate, will be able to work in the UK for 2 years. Okay, then they have to leave. They're not going to be able to bring their dependents with them for those 2 years or while they're a student. It may mean that they choose not to come to study here, but what's been found is that a lot of people have enrolled on courses, are working part-time and bring their family over, and they're not actually on those courses. So the government are trying, rightly or wrongly, to tie up some of those loopholes.